Have you ever wondered why you need that special official-looking paper for a rental agreement? Or what stamp duty really means when you're buying a house? Well, that's exactly what we're going to break down today. We're going to demystify the Indian Stamp Act of 1899 and make it super simple, whether you're a student trying to ace your exams or a professional who just needs a clear, quick refresher.
You've definitely seen it before, right? That special paper for legal agreements, or you've heard the term stamp duty thrown around. And it's very core, it's just a tax, but it's a very specific kind of tax, and understanding it is absolutely crucial for making sure your most important documents are legally valid. So let's dive right in.
And this right here? This is probably the single most important principle of the entire act. Get this, and everything else makes more sense. The government isn't taxing the act of selling a property or the act of taking a loan. No, it's taxing the piece of paper, the legal instrument that records that transaction. If there's no instrument, there's no stamp duty. Simple as that. It's a tax on the evidence.
So here's our roadmap. We'll start with the why behind this tax on paperwork. Then we'll decode some of that legal lingo. After that, we'll get into calculating the duty, figure out who pays and how, and then, the really important part, what happens if you don't comply. Finally, we'll see how this old law is catching up with the digital age. Okay, first things first. Let's tackle that fundamental question. Why do we even have this tax? Where does the government get the authority to charge us for our legal documents?
Well, the power to levy stamp duty is actually shared. Think of it like this. The central government handles the big commercial stuff, things like share transfers when you buy stock or insurance policies. But for pretty much everything else, all those everyday documents like property sale agreements or leases, that power belongs to the state governments. And that's the key reason why the stamp duty you pay in one state can be totally different from what you'd pay in another. All right, like any law, this one has its own special vocabulary. But don't worry, it's not as complicated as it sounds. We're just going to break down the three most important terms. Once you get these, you'll see the rest of the puzzle starts to fit together.
First up, the big one, instrument. This is the thing the whole law is about. It's not just any piece of paper. An instrument is a document that does something legally. It creates a right, it transfers ownership, it records a liability. A sale deed is an instrument, a loan agreement is an instrument. But just a regular letter you write to a friend? That's not.
Next, duly stamped. This sounds simple, but listen closely, because there are two parts to it, and both are critical. It's not enough to have a stamp of the correct value. That stamp also has to be attached in the correct way the law specifies. So if the rule says you need an impressed stamp, the kind that's pre-printed on the paper, and you just slap on an adhesive one, it's not duly stamped, even if the value is right.
And finally, executed. In the world of the Stamp Act, this just means signed. That's it. An unsigned draft of a contract doesn't need a stamp, but the second someone puts a signature on it, boom! The liability to pay stamp duty is triggered. That signature is what brings the document to life, legally speaking.
Okay, so we know the basic terms. Now for the nitty-gritty. How do you figure out exactly how much stamp duty you owe? The Act has some very specific rules for this.
Now this slide shows two situations that can be a little confusing, so let's clear it up. On one hand, you've got Section 4. This is for when one single transaction needs a bunch of different documents. In that case, you only pay full duty on the main one. The others get a tiny nominal fee. But on the other hand, you have Section 5. This is for one single document that covers several different transactions. Here, you have to add up the duties for each matter and pay the total.
So what happens if a document is a bit ambiguous? It could be described in a couple of different ways, and each way has a different duty rate. Well, Section 6 has a very simple rule for that. You pay the highest one. The law is written to protect government revenues, so when in doubt, the government gets the bigger cut.
We know what's taxed and how it's calculated, so the next logical questions are, who actually has to pay for this stamp, and what do these stamps even look like in the real world? Let's get practical.
Luckily, Section 29 of the Act is super clear about who's on the hook for paying, unless you agree to something different in your contract. For a sale deed, it's the buyer. For a lease, it's the tenant. For a life insurance policy, it's the person getting insured. But here's a fun little twist. For fire insurance, it's actually the insurance company that pays. And if a situation isn't specifically listed, the default rule is whoever signs the document pays.
Okay, so what do you actually get when you pay? Well, there are two main types of stamps. First, you have impressed stamps. This is what we all think of as stamp paper. The paper itself comes pre-printed or embossed with the stamp. Then you have adhesive stamps, which are more like the little revenue stamps you stick on a receipt.
They are physically different, and the law is very particular about which type you need for which document.
And please listen up, because this is a tiny detail that can have massive consequences. If you use an adhesive stamp, it is not enough to just stick it on the paper. You have to cancel it, so it can't be peeled off and used again. You do this by writing your name or initials and the date across it, so some of the ink is on the stamp and some is on the paper. An uncanceled stamp means the document is legally considered unstamped. It's a small step, but it's everything.
And speaking of massive consequences, this brings us to what's really at stake here. If a document isn't duly stamped, the fallout can be incredibly severe.
The first major consequence is this one word: impounded. It means that any public officer, a judge, a registrar, anyone who sees an improperly stamped document as part of their job has a legal duty to seize it. They literally take it from you. And getting it impounded is just the start. An unstamped instrument is basically legally useless. You can't use it as evidence in a civil court, no public official can register it or act on it. To fix it, you have to pay the duty you missed plus a huge penalty, which can be up to 10 times the amount you originally owed. It's so strict because it's the government's way of making sure everyone pays their tax.
Now, obviously, a law that's over a century old has had to evolve. The idea of physical stamp paper is slowly giving way to a system that's much more secure and, frankly, just makes more sense in the modern world.
So welcome to the future. E-stamping. It's a secure digital way to pay stamp duty, and it was created to cut down on fraud and make the whole process easier. In many states, this system is managed by the Stockholding Corporation of India, or SCHIL.
The process itself is a real game changer. You pay the duty online through your bank. Then, instead of getting a physical paper, you get an e-stamp certificate with a unique identification number, a UIN. And here's the best part: its verifiability. Anyone can go to the website, type in that UIN, and instantly check if the stamp is legit. This brings a level of transparency and security that was just impossible with the old paper system.
So after all these rules and sections, let's just circle back to the main point. The Stamp Act isn't there to make our lives difficult. At the end of the day, it is a fiscal law. Its number one goal is to collect revenue for the state. And pretty much every single rule, from the penalties to the calculations, is designed to make sure that happens.
And that leaves us with one final thought to chew on. We've already moved from embossed paper to e-certificates. So what happens next? As we move towards things like smart contracts on a blockchain, where transactions are purely digital, will a law built around the idea of a physical instrument even make sense anymore? It's a fascinating question about how this old law will have to keep evolving.